Well, hello and welcome back to my channel. I'm still a bit feeling a little bit yuck. I think I'm nearing the end of it all. My ear's still a little bit blocked, but fortunately the pain's gone away, which is good. I'm still so I've slept I've been sleeping most of the time since about Wednesday, and I thought, oh, I've just got to come on because it's just getting crazy out there. Did you know that there was another stabbing today at a shopping centre today? Can you believe that? I was absolutely shocked. This one's about 15 minutes from my house, but it was a fight between two people. But what is happening at the moment in the world? It is crazy. So I thought, well, we'll talk about crazy. Let's sort of talk about crazy. I want to also talk about this Bruce Lemon case that we've been following is a gift that keeps on giving, because Brittany Higgins, the victim of the SA, came out and made a statement, and now the politician whom she worked for, and the politician is now suing her for defamation, has come out and made a statement against her statement. So as I said, it is just everything is crazy. So I want to I want to start off. We'll look at the Instagram messages, and then we're going to go whenever there is, and I shared it on my community tab, an avoidance of doubt. We have to go back to the source documents. Now, when you're a law student, you are always told that, for sources, you have the main sources and you have secondary sources. Anything a judge says is, essentially gospel. So you go to judgments, and so you would quote from judgments. So rather than looking at the he said, she said type stuff of the claims and everything, let's go back and look at what the judge has said, because that is the most important thing here. And the judge has outlined what was outstanding. Okay. And so it's what the judge has decided. And there are some findings of fact that the judge made. And really, the judge has to go on a fact-finding mission in defamation cases. They have to find facts. Then they have to work out what the facts are, and then whether the law was breached. And that's really, we saw that in the Bruce Lemon case as well, which was fascinating. So I don't want to be on long. I've got an early start in the morning because I've been resting most of the weekend because I've got to work tomorrow. So I'm hoping to get through this quickly so I can go to bed. But let's just start with Instagram because now what I found to be very interesting is that when we look at her views, she didn't talk about sister wives there for a while. She went on to Seeking Sister Wives, and it sort of blew up in her face. And she's been talking about Ryan Anderson did not file a restraining order against Gypsy, but it says, I think it says on here, it says a petition. What she says here, a joint TRO. So they've got to both. She said is becoming messy in the media, and there appears to be some sloppy reporting based upon facts of court filings. There are salacious headlines about temporary orders of protection being filed by both Gypsy and Ryan. Here are the facts and screenshots. So the facts are, and again, I've gone through this, that they both have an order out. But what I find to be really interesting, so they do have a joint. Did she file? So she never actually shows the whole document, and I always get really concerned when so she's actually taken out a whole part of that. I always get really concerned when you don't see everything. This says also seeks to keep financial records and everything. Says he's not filed a single document in the case, and he does not have an attorney. I don't know when this was filed. I mean, he may have served. And she said, TMC today confirmed that their source close to Gypsy is connected to someone, to Ryan. Ryan is publicly blaming Gypsy for the divorce. Again, he should be hiring an attorney and handling his court. Neither party is restrained for DV. But so the fact is that they're both. But then she's gone on to she's got more human trafficking allegations and claims here. More human trafficking claims. But this is the one that I'm interested in. Imagine sued by someone in April 2022. Then imagine 2 years later, you still not have received any discovery from them, and they have yet again missed the deadline for discovery. It's almost like the lawsuit is solely for the purpose of harassing me. She says, no discovery, no depositions, even after a motion to compel. It's like Robert Shin wasn't really serious about this lawsuit, given it's been 2 years. Now, this was filed a day ago, and we will see under the new orders that it was everything that Friday was the deadline. So this was filed. Anyway, not to mention Docu's trying to stop. Guess the lawsuit didn't work in trying to stop the series. I don't need legal advice. Please refrain. I have a competent team that's what to do. It says, I saw Miranda with her mum and sister on here recently. I was shocked. She said, don't be. It's not real. It's all for show. No, Miranda has to sign an NDA with the church, allegedly. Someone else says abusive process claim. Said, girl, trust me, we have all the plans. Is this a documentary on polygamy or the Mormon church? No. Any news when the docu-series will be airing? You'll find out when it's announced. Oh, sorry, you've got to deal with this. People love to harass you. Can you get the lawsuit dismissed? Not yet, but eventually. Has your Facebook page been hacked? It's showing its admins are in Kosovo. Yes, I thought so. I unfollowed it. Can you sue him for your legal costs? Someone says that they appreciate the channel. Proves they have subtle to sue you, bunch of idiots. It keeps your name on their lips to keep reporting. So let's have a look. So she, according to her, they have not met their discovery. That's the old one. Oh, hang on. We'll go back, find a new one. All right, so let's go. And then I'm going to show you how to find the information so that you can do your own research, because it's really important. So this was the judgment. This was the motion, the order of motion to compel. This was dated the 29th of January 2024, okay? So remember that, okay? 29th of January 2024. So the above mention came before the Honourable Kari Willis, of the Judge of District Courts, for hearing on November 15, 2023, on the parties' motion to compel. Amber Stavick appeared on behalf of the plaintiffs, Jennifer Moore on behalf of the defendants. The court held a phone conference with the parties prior to the hearing and requested they meet and confer to narrow the pending discovery disputes. The parties submitted correspondence to the court on October 30, 2023, regarding the outstanding disputes. The parties presented oral argument to the court on the 15th of November 2023, and the court took the matter under advisement. Now, so they're saying that they actually had already had a discussion. The lawyers had to have had a discussion, and they had to show to the court that there had been a discussion about discovery and what was pending. Okay? Now, we now hit the finding of facts. This is what the judge has said the facts of the matter are. These are findings of fact is generally undisputed. So the plaintiff's 7M Films is a talent management company, and Robert Shin is the CEO and sole owner. Plaintiffs Miranda and James Derrick are husband and wife and associates of Mr. Shin. Plaintiff's business is in the field of social media communications and marketing. Additionally, they broker deals between performers, particularly dancers, and commercial venues. So the judge has read all the documentation and has come out and said this is a fact, a statement of fact. Miss Paulson runs various social media accounts with substantial reach, numbering in the tens of thousands or hundreds of thousands of followers, particularly on Instagram and YouTube. Again, I would say, yep, that's fairly, that's a fact, right? Plaintiffs allege 9 causes of action against defendants. In the first 2 counts of defamation per se, underlying the remaining counts. In summary, plaintiffs allege that Ms. Paulson, via her Instagram page and other social media platforms, defamed plaintiffs by posting false statements about 7M and associated individuals. Plaintiffs maintain that Ms. Paulson's social media posts claim the plaintiffs were involved with Shekinah Church, which plaintiffs argue that Ms. Paulson characterizes as a cult. Plaintiffs further claim that Ms. Paulson has acquired and published court documents subject to a protective order involving the plaintiffs, and that Ms. Paulson has stated that the plaintiffs engage in criminal conduct, including human trafficking, waterboarding, and kidnapping. Plaintiffs' other claims are rooted in the same allegedly defamatory conduct by defendants, and are pled as tortious interference with contracts, international interference of prospective advantage, deceptive trade practices, negligence, and intentional infliction of emotional distress. Okay, so that is just a very quick summary of the case there. All right, so now we've got conclusion of law. So Minnesota rules 2602 govern the scope and limits of discovery. So it's quoted there. The court may limit discovery that is unreasonable, cumulative, or duplicative, obtainable from another more convenient source, or underlie burdensome. And again, a case is quoted there. So essentially, they're saying that here is parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense, and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of discovery in resolving issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. So essentially, you just can't ask for something for the sake of asking for something. It actually has to be relevant to the case at hand, is essentially what they're saying. So we get to plaintiffs' interrogatories. So they listed in the plaintiffs, they had all these interrogatories they wanted. 1, 2, 3, 4, 5, 6, 7, 8. I could go back and we could go back and go them. But anyway, plaintiffs have demonstrated that the requested information relates to claims and damages asserted in this lawsuit. By her own admission, Ms. Paulson has a massive social media presence and discussed plaintiffs on several platforms. The sources and veracity of this information is relevant to the claims asserted by the plaintiffs. The information is not overbroad, as it's limited to statements made and information obtained by the plaintiffs within a specific time period. Now, if you wanted to go back, the interrogatories, you'll find that it's about how many subs were purchased, how many so that's that information. Actually, I should have pulled it up. Let's just pull it up now. So we can go back. So I just also, for those of you that I put this, I want to show you how you get the information. So you put in the website here, okay, and you want to go to case search, and you want to put in Paulson and Catherine. That's all the information that we need. Okay, so if you're wanting to know the facts of this case, then I would suggest that this is the way you do it. We go down and we see that there's a couple here, and we want the 7M Films versus Robert Shin. You've also got all the information there with the Todd Chrisley case as well, but that's closed. And then we go to case detail, view case details. So then we've got here that was filed on the 4th of the 5th, 2022. We've got the judge that's open, and there is a protective order. So there are things that we can't see, and we know from the protective order there is some things that she can't see and the parties can't see. So it was initially assigned to a different, so it's got where it's assigned. So we've got the scheduling order I need to download. All right, so we've got all of these in here. All of these in here. All right. Responsive motions are the document under document. Notice of motion and motion. All of this is in here, okay? Affidavit of defendant, affidavit of attorney. There was an answer there. There's been lots and lots and lots of documents filed in this case. All right. Lots and lots and lots. You got the summons and complaint, affidavit, correspondence, amended summons and complaint. Proposed order of document. Then there's been lots of proposed orders and documents. There was originally a scheduling order, which got thrown out the wayside. There was an order denying the motion. There was another notice of filing an order, notice of motion, memorandum. So there's lots and lots of stuff here, because you'll find that there was they both filed motions to compel as well. So we're going to need this. So the reason why Katie Joy's all sort of got her knickers in a twist, okay, and her knickers in a twist, is that this was the scheduling order that came out on the 15th. So it had deadline for discovery, filing of additional pleadings and joint statement of the case. April 19, 2024 shall be the deadline for exchanging written discovery. It's only written discovery. All right? And they've got to have a joint statement of the case. Depositions, now she's carrying on about depositions. Depositions shall be conducted by July 26, 2024. So when she's carrying on here, no discovery, no depositions. Well, Katie, where is it? According to the scheduling order, depositions don't need to be done until July 26th. The alternate dispute resolution to be used in this action shall be mediation. So the judge has said they've got to try and mediate. The deadline for completion of the immediate ADR shall be the 31st of December. Upon motion by any party or its own initiative, the court may at any time issue an order for an ADR process. So if they do mediate, then they've got to let the court know. Non-deposition motions shall be served and filed no later than August 23. Deposition of the motion shall be served no later than September 23, 2024. So we haven't even got to the time of depositions yet. And she posted this saying, now just because she hasn't seen them doesn't mean that nothing's been filed, because it's between her lawyer. Her lawyer can see them and can take notes, because that was part of the protective order. So for this, and then says defendants claim that plaintiffs are not entitled to that much information sought by plaintiffs because of journalistic privilege, and or because information qualifies as journalistic notes. The issue of whether or not Miss Paulson is a journalist has not but yet been presented to or decided by the court. To the extent the defendants maintain the sources of some of this information are confidential informants or qualify as journalistic notes, they can provide that information to plaintiffs pursuant to the privilege log. So we went through the privilege log and said that, that process of how that privilege log is done. And she can give the information without giving away any of the sources. Okay, so there is a way to do that. So essentially, the plaintiffs have put what they've requested. They've said, so she's essentially said they've got to do it. So Katie Joy has to do it. I think most of what the compelling was to do with Katie Joy had to provide more information than them. Plaintiffs' requests. The court also finds this information to be discoverable. The issue of whether defendants were compensated, how much they were compensated, and by whom they were compensated from January 2020 to present is relevant to defendants' motives in discussing plaintiffs on social media platforms, including the depth, length, and substance with which the plaintiffs were the focus of Miss Paulson's discussions. So here they wanted her financial stuff, and the court has said you've got to provide it. Plaintiff's request. Similarly, these requests are discoverable as they relate to defendants' motives in potentially gaining financially from their discussions regarding plaintiffs. Defendants offer no legal support for their claim that the production companies would be required to make an independent argument regarding any disclosure of any contracts they entered into with defendants, and the court does not find that persuasive. So she has to show whether she had any contracts. Defendants' interrogatories. So this is what she wanted. These interrogatories, as written, are overbroad. Defendants contend that they are seeking evidence of statements against interest. However, the interrogatories are not limited to statements against interest, nor are they related to a specific time period. Furthermore, they do not identify the general substance of the statements the defendants are seeking. So she had those rejected. Interrogatory 8 was also deemed to be overbroad. Defendants stated that they would limit the communications to communications about the lawsuit or claims in this litigation, but the interrogatory seeks information prior to the commencement of this litigation. Defendants' limitation does not render the interrogatory answerable. So she didn't get that one. Number 10 and 11, these request information relevant to the claims, so they had to provide that. So she got that one. Katie got that one. This interrogatory is overbroad and not likely to leave. So again, she's had another one injected. She had another 1, 2, 3, 4, 5. Yep, she's had another 5. Said yes. The request is relevant to claims of defendants in this lawsuit and should be limited to the time period from January 2020 to present. So that's yes, she got it with limitations. Again, her other requests were overbroad, and then this one was relevant. So plaintiff's motion is granted with respect to dispute and request for promotion. Defendant's motion to compel is granted with respect to interrogatories and request for production granted in part. Respect to request of promotion, the remainder of the defendant's motion to compel is denied, and they abide by the protective orders. Okay. So remember, the plaintiff is 7M and the defendants is Katie Joy. So let's just look at that again. The plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. Defendant's motion to compel is granted with respect to interrogatories 10, 11, 14, 15, 16, 17, 19, requests for production of 9, 14, and 20, and granted in part with respects to 6 and 7. The remainder are denied. So she didn't get it all her own way. So when she's talking about this, I don't know how she can say it when she actually had most of hers disputed. So so then from that, we got to this, where they had a scheduling order because they had to do a scheduling order. And if, for example, so my next question would be, if she's going and say that they've not given anything out to anybody, why didn't that come up at the court date in March? Why didn't her lawyers bring that up as a concern and have the judge deal with that? There would have been a discussion for that, because it's a deadline for discovery. They would have known that. That would have all been done. I don't understand, if it was all outstanding, why nothing was done at that point. So I'm having a lot of trouble with this. No discovery, no depositions, even after a motion to compel. Remember, she only got part of her motion to compel. She didn't get a full motion to compel. That's why I'm saying it's very, very important to look at the facts of the case, which we have done. We've been looking at the facts. The facts state that she had part of her motion to compel granted, the rest was denied. They had to do less than what she did. So that's why I'm having lots of trouble with what she's saying there. You know, but I'm interested to see what you think. As I said, I've taken you through and shown you how to find the cases. I would suggest that if you really want to know what's going on, that you download it and look at it yourself, because it's really important that you get your head around all of this. And it's also very important for me to make sure that the facts are getting there. So that's really what I want to talk about, really. And then what else has she got on here? She was talking about this. I don't know anything about this. that is to do with down here, isn't it? She put something down here, I think, about it. I don't know. The other thing is that there's been a date set for Todd Chrisley's appeal too. So I don't know whether no one's talking or whether you're just all in shock or whether you're just all stealth watching. Because it feels like I'm talking to myself at the moment. Oh. Okay, so apparently that happened on Friday. Apparently they appealed the bank fraud. So this was High Court hearing is a step towards bringing the convicted parents home. So the accountant who they hired who's also serving time in prison also wants his conviction thrown out and granted. A 3-panel judge in Atlanta on Friday heard arguments from lawyers for the 3. So that's Peter Tarantino and the Chrisleys. But the prosecutor said they engaged in a extensive bank fraud and that hid their earnings from tax authorities while showcasing their extravagant lifestyle. 2 of Chrisley's children, Savannah and Chase, were joined by more than a dozen supporters in the gallery. Savannah spoke to reporters after the hearing, saying she talked to her parents Thursday night, and they're doing as well as and best they can be, and hope Friday's hearing is a step towards getting them home. So in 2022, a jury found them guilty of conspiring to defraud community banks out of $30 million. They were also found guilty of tax evasions. Oh, hello. Oh, you're tired. Hello, Barbara. Oh, hello, Rachel. I don't know much about this case, but I appreciate the way that you explain things. I'm becoming more interested. Yeah. Oh, look, Rachel, it's a bit of a train wreck, which is why I've been, if I went through everything, it would be very confusing. And that's why I'm sticking to the later stuff. And I want to show you how you can go and read it. Yeah. It's really about calling out misinformation, because what I just read about what the judgment stated, that she got partial motion to compel, she's implied in her Instagram post that she got a full motion to. She's the one that has to comply fully. So Alex, the lawyer for the Chrisleys, argued that an IRS officer lied on the stand about the couple still owing taxes at the time of trial, and when she knew no taxes were due, and the prosecutors knowingly presented and failed to correct the false testimony. They relied on information they knew to be incorrect. The prosecutor rejected that assertion, saying that when the IRS officer testified, she and prosecutors were unaware of some tax payments the Chrisley had made, but she said the couple did still owe taxes at the time. Now, interesting, though. So, Circuit Judge Robin Rosenberg, who heard both sides during the hearing, seemed skeptical of the idea that prosecutors had conspired with an IRS officer to present false information, saying evidence the defense presented in brief seemed like pure speculation. The Chrisleys' lawyers also argued that the trial judge was wrong. Hello, Lulu. To allow certain evidence without requiring prosecutors to show it wasn't obtained during unlawful search. And they argued prosecutors failed to provide enough evidence to convict the Chrisleys of tax evasion and conspiracy, showing that they had used a common entertainment industry practice to receive acting income. They also argued prosecutors failed to produce any evidence that Julie Chrisley participated in bank fraud. They said the judge erred by ordering restitution and forfeiture of assets. Todd Chrisley should be acquitted on the tax evasion conspiracy counts and given a new trial on the remaining counts, his lawyers argued. Alternatively, the appeals court should send the case back to the trial court to hold a hearing on his claims that the IRS officer lied and evidence improperly admitted. Now, there's actually very interesting that the prosecution admitted that there had been money paid back that they didn't know about. That, to me, seems a bit weird, that you wouldn't have actually done your due diligence and made sure you had all your ducks in a row. So they may, it depends on what they could possibly, I mean, I don't know. Julie Chrisley should be acquitted on the 5 bank, her lawyers argue. They also say her sentence on the remaining charges, including $17.2 million in restitution that her and her husband were ordered to pay, should be wiped away, and she should be resentenced on those counts. They're not saying they're innocent here. They're just saying that there's been some facts left out. Prosecutors argue there's sufficient evidence to support at trial to support the charges and jury verdicts, and that the evidence were properly obtained and admitted. Peters argued that there was no evidence that the IRS officers' testimony affected the jury's verdict. Even if the Chrisleys eventually paid what they owed, later actions do not nullify the crime. Don Samuel, lawyer for Tarantino, argued his client was harmed by being tried with the Chrisley when he urged the court to reverse Tarantino's conviction and return his case to a local court for a new trial. Well, Tarantino did certain things that ended up facilitating the Chrisley's fraudulent conduct. There was no evidence he did anything intentionally to facilitate that conduct. The scope of the charges against Chrisley's dwarfed the evidence against Tarantino and prejudiced the jury against him. So it's interesting. Could go either way. So again, because of a settlement that she's got with Chrisley, she's not supposed to talk about him either. So that's also very interesting. And we know that she did, because she said that he was found guilty of something that has to pay money out. So yeah, it's all a little bit of a mess. But you know, as I said, it's very important that we look at everything. So just to reiterate, the deadline for discovery, filing of additional pleadings and joint statement of the case. They've had to come together and do a joint statement of the case. These are what we agree on. These are what we need. This is what we'll need to argue at court at trial. And then depositions. So Katie Joy is talking about, no depositions have been done. Depositions shall be conducted by July 26, 2024. By my understanding, we're still in April. So April, May, June, July, we're still got another 3 months before they're due. And the court wants them to try and mediate. As I say, mediation is always the preferred. Mediation is always the preferred, because one of the objects of lawyers is to try and expedite the solution the most cost-effective way. And sometimes and sometimes that is using mediation. All right, so let's just have a look. I want to look at take a break from Katie Joy at the moment, because I've just, what's the time? I've been online for about half an hour. Yeah, as I said, it's not going to be long because I'm still not great. I need to get some big sleep before tomorrow. All right, so I'm going to Brittany Higgins, because she released a statement today. I said it was a bit of a mess. But Brittany Higgins released a statement on the judgment about it. I think what's really important here is that we remember that what we discovered is that she was actually AR'd in her employment at Parliament House. And the thing that I'm really, really annoyed with at the moment is that we're still not really getting anything. from Parliament to say this shouldn't have happened. We're really embarrassed by it. But she hopes the case sets a new precedent for survivors. So she hopes Justice Michael Lee's judgment in the Bruce Lemons failed defamation case will see a new precedent set for how courts consider testimonies from victims of sexual assault. In a statement on Saturday, Higgins said she was devastated. A rapist was given nationwide, I know I said the word, platform to maintain his lies about what happened. She hoped people who contributed to Channel 7 Spotlight program last June, in which Lemon was interviewed, will reflect on the decision. She also apologised to the former Defence Minister Linda Reynolds and her then Chief of Staff Fiona Brown after Lee's judgment rejected Higgins' claim of a political cover-up. She says, "I was raped. No judgment was ever going to change this truth," Higgins said in her statement. "I lived with the shame, humiliation, and fear of what telling my story would mean for my life, my career, and like many victims, I was to be believed or supported." In Monday's decision dismissing Lerman's case, Lee said the former Liberal staffer was not defamed by journalist Lisa Wilkinson and Network 10 when the project broadcast the interview with Higgins on Monday the 15th of February 2021, in which she alleged she was raped at Parliament House. He found that on the balance of probabilities, Lerman raped her on the minister's couch in Parliament in 2019. But Lee said allegations had been a political cover-up were objectively short on facts, but long in speculation. Thanks to Justice Lee for his trauma-informed approach, recognising reactions to assault can vary widely. In doing so, I hope he has set a new precedent for how courts consider testimony of victims surviving SA. She noted thousands of staff who'd worked in the Commonwealth ministerial offices. Higgins said the toxic culture of Parliament House was not something she just imagined and felt compelled to tell her story. She noted thousands of staff who'd worked in the Commonwealth ministerial offices on both sides of politics subsequently came forward to contribute to Kate Jenkins' review of parliamentary culture. Higgins said that while she did not agree with all of Lee's findings, she respected his observations about the many people scarred and damaged in the aftermath of my rape. She said there were people who had been unreasonably wrapped up in years with the media discourse or battles in relation to my rape. Linda Reynolds and Fiona Brown have also been hurt, and I am sorry. My perception and feelings about what happened in the days, weeks after my rape are different from theirs. I deeply regret we have not found common ground yet. She said she hoped she could resolve their differences better. Now, interestingly enough, Linda Reynolds is suing Brittany Higgins for defamation. And she released a statement, which I find to be, you told me what you says, "I appreciate Ms. Higgins' apology, not only for me, but to Fiona Brown. I sincerely hope that Justice Lee's findings in relation to Ms. Higgins' allegations of rape will give her peace. The insight of Justice Lee demonstrated in his judgment has rightly been commended, both for his findings on the rape allegation and the claims of political cover-up and mistreatment. My legal action against both Ms. Higgins and Mr. Shiraz were never about the allegation of rape. My actions deals with what Justice Lee's exposed as a false allegation raised 2 years after the rape. Allegations that I and my staff, specifically Fiona Brown, not only failed to support Ms. Higgins, but subject her to a dreadful and damaging political cover-up. At enormous emotional and financial cost, I fought for 3 years to expose the truth in relation to my conduct. This personal financial cost, in large part, has been incurred due to the Attorney General barring me from defending those same allegations in Ms. Higgins' civil claim against the Commonwealth." She's actually having a bit of a sook here because she's not allowed to have the taxpayers pay for her court case, which I'm really happy about. Looking forward, I hope Ms. Higgins' olive branch, I welcome Ms. Higgins' olive branch and commitment to engage with me to reach a resolution. I hope Mr. Shiraz will now make a similar approach. It is important to note that Ms. Higgins said in her statement yesterday, observed that she does not agree with all of Justice Lee's findings. My perceptions and feelings about what happened in the days and weeks after my rape are different from theirs. I deeply regret we have not yet found common ground. Which still lies between us are not different perceptions. What lies still between us are not different perceptions. It is a fact that Ms. Higgins received our support and there was no cover-up. The common ground now find must be based on truth. As a matter of law, neither us or Mr. Shiraz are bound by Justice Lee's decision. If Mr. Higgins does not accept Justice Lee's findings on the claim of cover-up mistreatment, then regrettably it'll be proved again in our trial set for July. What do you think about that statement? She's been criticised for the statement, and people are saying that yes, she did. She sued Higgins for defamation. Yeah. Mediation failed. The court ordered mediation, and they could not find common ground. But let's not forget that Reynolds did call Higgins a lying cow in Parliament. So, I did refer to Higgins as a lying cow. She forgets that statement, and because and again, here's another question: should a politician be allowed to sue somebody for defamation because of something that happened in her office? The incident happened in her office. Oh, you found about the lying cow? Yeah, she called her a lying cow. But here's the other thing. The defamation, like the whole thing about the cover up was all about the fact that it was the defamation case against Bruce Lerman. So this was in 2021. Defence Minister Linda Reynolds has retracted a comment calling the alleged rape victim Brittany Higgins a lying cow and has apologised again for making the remark. She made a remark after Miss Higgins, a former staffer, went public with the allegation that a colleague had raped her in the minister's office in 2019. She made the comment in front of staff in her office, but in the statement said she did not mean it in the sense it may have been understood. Given the comment was... She does, Rachel. Very good. Yeah, that's a very good point. Given the comment was made public, which I never intended, I also want to retract it and unreservedly apologise to Brittany Higgins and acknowledge the hurt and the stress it caused. She also received Brittany Higgins also received compensation from the government too for the incident, and she's had to fight for 3 years over the fact that people have been calling her a liar. She's probably got some indication. But Rachel, it's been Linda Reynolds actually, because Brittany Higgins and her boyfriend moved to France just to try and get away and put distance between the whole incident, and Linda Reynolds has frozen her assets, so they can't get any of their savings they've got in Australia because she's frozen their assets. So she's and to cry about the fact that you've got to pay for the defamation case out of your own pocket, how does she think normal people have to do it out of their own pocket? We all don't have rich friends like Bruce Lerman. Okay, and the last thing I want to do, I've been collecting, I've got windows here open and everything. I've been collecting. This one's got me a little bit astounded. This has got Ontario resident wants both sexual parts of a human body. Wants both a vagina and a penis, wins public funding for unique surgery. This is Canada. A court has ruled Ontario must pay for it, for a penis-bearing vagioplasty for a person who identifies as neither fully female or fully male. Ontario has been ordered to pay for the surgery for a resident who's seeking to have a vagina constructed while leaving the penis intact. Told you it was bizarre. Denying the procedure would infringe on the person's charter-protected right to security of the person, an Ontario court said in its ruling. The unanimous decision by a 3-member panel of judges of Ontario's Divisional Court could expand access to a novel bottom surgery for people who identify as non-binary, meaning they are neither fully male or fully female. The Ontario resident identified in court documents as KS has been locked in a legal battle with Ontario Health Insurance Plan since 2022, when OHIP denied a funding request to have a penile-preserving vaginoplasty performed at a clinic in Austin, Texas. The surgery, which is not available anywhere in Canada, involves creating a vaginal cavity opening without removing the penis. The surgery, KS33, was born male but identifies as female dominant and uses a feminine name. OHIP denied her request for funding, arguing that the procedure is not included on its list of sex reassignment surgery procedures and therefore not an insured service. KS appealed OHIP's decision to Ontario Health Service Appeal and Review Board, arguing that forcing her to have her penis removed would invalidate her identity and be akin to an illegal act of conversion therapy. Hang on a minute. But you're identifying as a female, but you want to it's like having your cake and eating it too. She was also worried about the risk of complications and urinary incontinence from the urological rereading and the risk of orgasm dysfunction. She argued the procedure she's seeking abroad is like a standard vaginoplasty performed in Ontario, but without the additional procedure naming the penectomy. The appeal board overturned OHIP's decision, ruling that the vaginoplasty is among the genital surgeries listed for public coverage and need not inherently include removing the penis. The board therefore ruled the procedure eligible for public funding. OHIP appealed the board's decision to Divisional Court. Hello, Keno, arguing the review board erred in finding that a penis-bearing vaginoplasty is specifically listed as an insured service, and it failed to consider that the unorthodox procedure is considered an experimental procedure in Ontario and therefore not eligible for funding. Just because a vaginoplasty is listed as an insured service doesn't mean any type of vaginoplasty qualifies, the OHIP court argued. The court disagreed. Vaginoplasty and penectomy are listed as discrete separate service areas listed surgery eligible for funding. The court said the fact that most people who have a vaginoplasty done have it done in a way that also involves a penectomy doesn't change the provision. If the province had intended for only one type of vaginoplasty to be insured, vaginoplasty with penis removal, it should have drafted the list differently. The court said the appeal board's conclusion was also consistent with standards of care developed by the World Professional Association for Transgender Health, an influential group whose guidelines for gender-affirming care for children and youth were found to lack developmental rigor in a sweeping review released this week. The WPATH standards especially refer to vaginoplasty without penectomy as a surgical option for some non-binary people. Justice Davis wrote in the court ruling, while the court said it didn't need to address charter arguments if there was any ambiguity considering what should or shouldn't be covered. The review board's interpretation was also consistent with the charter, values of equality and security of the person, the court added. The charter protected the right to the security of the person, safeguards individual dignity and autonomy. Davies wrote, requiring a transgender non-binary person born male to remove their penis to receive state funding for a vaginoplasty would be inconsistent with the values of equality and the security of the person. Such an interpretation would force a transgender non-binary person like KS to choose between having surgery, penectomy, which they do not want, and which does not align with their gender expression, to get state funding on the one hand, and not having gender-affirming surgery at all on the other, Davies, right? Such a choice would reinforce their disadvantaged position and not promote their dignity or autonomy. I'm trying to work out how this would even work. I'm more non-binary than female. I'm trying to get it and agree it would be high risk to you. So that she has to remove it. Well, so you say, Rachel, that you're more non-binary, but I understand. Yeah, I mean, I would thought though I'm not saying that she should have to remove it. I'm wondering why she has to have the other bit done, because where does it go? OHIP's appeal was dismissed and the province ordered to pay KS $20,000 to cover legal costs. This is a significant win for transgender and non-binary communities. KS lawyer John McIntyre told the CTV News Toronto. We hope that OHIP decides. Oh, okay. So the V would validate the gender distress, right? Okay. Decide to accept the decision of the court rather than seek leave to appeal so that KS can move forward with her surgery she's been trying to get for years now. KS is very happy with this unanimous decision, McIntyre said in an email to National Post. The Regional Court determined the existing language of the Health Insurance Act and scheduled benefits clearly provided for coverage of the procedure sought. In earlier reports, National Post was told that there was gender-affirming surgeries at the Texas clinic ranging from $10,000 to $70,000, depending on what was done. So my understanding is that they've got to go to Texas. So Canada is going to have to, is what I'm seeing, having to go to Texas, and so wanted the Canadian government to pay. Is that what I read? I'm sure I saw that about Texas. Oh, yes, when performed in a clinic in Austin, Texas, which is because it's not available. I have issue. I mean, then we do. If you're having surgery outside of your country, should then you be able? Should then should the government have to pay? This country, I understand, but then I understand that it's not done. I could see how. I mean, there's health risks. There's risks with any surgery that you have. Yeah. Well, see, this is why I can see why public funding is questionable. Yes, if it was in Canada. So, from what I can understand, the court has ruled that the government has to pay for this funding, this surgery in another country. That's my interpretation of it, and that's where I sort of have issues with it, because now we're talking about another country. But then, for obvious reasons, they don't do it in Canada. Maybe, But I do want to look at the CAS report that came out of the UK in a later video, because the CAS report is the first lot of data and the first report that's come out with young people and transitioning, and because one of the things that has occurred, is that particularly with puberty blockers and putting hormones into a young body, is that the effects, there's not enough data or research to see what the long-term effects are. And the study out of the UK has shown some shocking results about detransitioning and reasons for why people have detransitioned. And the number one reason that came out of the CAS report was that they weren't told all of the things that could happen to them. So I want to look at that, but we'll do that and that's gonna be not. There's no judgment here. You can, but it's just I'm a facts. I like facts, and I know that I personally have issues with pumping hormones into children. Anything to do with minors at all. I think you have to be old enough to make your own. You have to be old enough to be an adult. And then there's questions about at what stage of adulthood, because the brain, the research is there to say the brain doesn't fully develop to the age of 25. So until we're 25, we technically still have limited reasoning, and our brain is not fully developed. And in Australia, there's parts of Australia that's raising the minimum age of criminality, and it's been raised to 12. There's still arguments about raising it to 14 around the place, because of the fact the brain, when you're so young, you're still learning things, and they have found that the earlier that you can get some type of behavior problem in them, the younger that they are, more time, the greater the distance between getting to the age of 25, they're seeing that you can actually change somebody. That's why I get really upset when I hear of children, 14, 15-year-old children in the US being treated like an adult, because the brain does not fully function till they're 25. So they have no concept. And as I said, if you got in there and you started to do counseling and that, the research is showing that. So there is also a push to keep juvenile to raise the age of juvenile prison. At the moment, they can be if you're younger than 18 when you commit the crime. If you're a juvenile when you commit the crime, you stay in prison. You stay in juvenile prison right throughout your sentence until you're certain. I think it's 21 or 22, and then you go to an adult prison. But there's also talk of making the juvenile prisons go up to 25, so that there's a greater chance to rehabilitate them. All very interesting things. So I mean, there's lots of interesting things out there, but it's 25 seems to be the magic age that all the research agrees on. And so for me, I would be really looking at, I'd be pushing towards making sure the brain's fully developed. And the other research out is that the older that someone is when they transition, the more likely they are to stay too. So I've been doing lots of reading on that. I fully don't understand a lot of it, because I'm a female and I like my, and in this States, 5-year-old boy. Wow, that's really sad. So really, you're saying that so that person in that article, then, Rachel, you're saying would be agender rather than non-binary. Is that right? Because they said they don't go. You got 75 years. Well, see, the other thing is, when there's 5 years old, and the other thing is, particularly with kids that are brought up in domestic violence situations, the younger they are when they see it, they think it's acceptable behavior. So if we can sort out some of the stuff around that, I mean, I just don't understand. Just don't understand any of that. I mean, and look, I don't know the circumstances of it, but I mean, 5-year-old boys can be inadvertently rough as well. You have to know. And that's why when they do crimes now, they do take in a lot of consideration into the background, because if you're a child that has seen a parent beaten every day, and then you've gone and beaten somebody up, well, then that's how you would have learned that's how you deal with your problems. So a lot of it now is, yes, you still did something wrong, but we need to also try and fix that behavior. But see, for me, I'd say a 5-year-old boy wouldn't have a concept. So in Australia, 12 is the age of criminality. So anyone under 12 does not have the capacity to know the difference between right and wrong. Now, you could argue that. I mean, there's lots of arguments about that. So it's called the age of criminal responsibility. So it's I thought they raised it to 12. But see, so you have no criminal responsibility between 10 and 12. Up to the age of 14, you can have diminished responsibility. So they actually would have to, yes, age of criminal responsibility should be raised by 12 by the end of 2024. Children aged 10 and 11 will not be held criminally responsible for their actions. Once it gets to 12, so there'll be 12 and from up until the age of 14, up until the age of, so between 10 and 14 at the moment, it's limited capacity. The prosecution actually has to prove up until the age of 14 that you knew the difference between right and wrong. And again, it's called diminished responsibility. So it's they're also talking about raising it to 14. But yeah, it's getting maybe. Oh, so it's confusing for you, Rachel? Oh, yeah, because I found it really confusing. I'm finding it really confusing because for me, I thought, for me, I thought non-binary was neither male or female, but they seem to be presenting themselves as a female, which has got me confusing because then I'm going, well, you know, if they've changed their name to a female name, they're born male, they've changed their name to a female. Yeah, I'm just a bit confused. Screwing your kids not knowing though. I was telling friends and family since I was 4 years old I was a girl boy, and I stopped on my. Yeah, I mean, look, I mean, I don't like wearing dresses, but that doesn't mean that I'm a boy. You know what I mean? Like, I just wasn't a very girly girl. I was more of a tomboy, and that's fine. But I'm really concerned now that because I don't like wearing dresses, that people would say, well, you're a boy. Well, no, I don't want to. You want to be a boy. So, interesting. The UN actually recommends 14 as the age of criminal responsibility. So there seems to be a consensus around that. So United Nations has said that 14. Which I would agree with. I mean, but you think about it. You think about everything that's happening. But, you know, kids have to go through puberty. They go through all these changes. And I have issues. So the UN, so this is an article from the UN. Major UN rights review need to raise the age of criminal responsibility. So in the Universal Periodic Review, UN countries questioned Australia about its human rights record and recommendations for improvements. 122 countries highlighted the need for Australia to better protect people's rights. The fact is that children as young as 10 were being locked up in jails across the country is clearly an issue. And it also has to do with asylum seekers and that. So that was also... and also a lot of Aboriginal and Torres Strait Islander children have been locked up as well. So that's where the pushes come from. I'll put this in here if you'd like to have a read of it. Yeah, to show. So I think it's. Look, I think 14's a good age. And look, I'm really not happy. I'm not diminished what Ethan Crumley did. I think it's that boy, but he's in jail with adult men, which I think is very vulnerable. He was 14 when he committed the crime, and I'd say, based on what I've seen about his upbringing, and the fact that his parents are also being jailed, I think that means that I don't think that he would fully know what right and wrong was. Anyway, Australia locks up vulnerable children as young as 10, taking childhoods away, causing serious harm at crucial times of development when they're being shaped into adults. The UN has benchmarked 14 as the absolute minimum age of criminal responsibility, and that's why I'm saying I think that the Crumley boy, and my other argument would be is that he showed all the signs that he was in trouble. And nobody, even the school, nobody paid attention to the signs or the warning signs. I think the school did, but the parents did it. So more blame on the parents than I do on him. And I was horrified when I heard that he wasn't even being educated in prison. I was horrified. But anyway, but the US seems to like to do that. I mean, I know Australia, they get educated. You know, they have teachers. I believe they have teachers that go in and do the juvenile, and they should be educated. You know, as I said, they've still got a long life ahead of them. But anyway, that's just my 2 cents worth. Anyway, I've been online for over an hour now. I need to go because I need to get up early, and go to work tomorrow. The dad, I blame the dad, Keno. I really do. And I think he is an innocent victim in that. My heart breaks. I can't even read about that case or look at that case because it just devastates me so much. I remember I saw, and I saw his lawyers. I saw his lawyers trying to push the judge to allow him to be educated, and the prosecution saying, "Oh, he doesn't deserve to do it because he did this and this and this." And I'm yelling at the computer, going, "But he's 14. He's 14." You know. So anyway, that's just my rant. Gender is huge spectrum, and is still female, just a little closer to the middle. Yeah. But anyway, look, I wear more dresses now. Yeah, I know it's on there. I know I can't watch anything about that. It just devastates me. And the more that I've studied, the more study that I've done on law, the more my whole perception. Sorry to go on about gender so much. No, it's good. It's good, Rachel, because as I said, I don't understand a lot of it. And when I was reading that article about Ontario, I could not for the life of me understand why you would want to have both options, although you sort of made it a little bit more understanding. I still don't fully get it, and I don't know how it will work. But my whole point is, should the people of Canada pay for something that isn't even a medical procedure that's not even happening in their country? That's my big thing. That's probably more of it. And then how does it work? You know, and I do know, I mean, there are a lot of people, and like I have big issues about mutilating children. There's a couple of 18 or 19-year-olds that talk about, you know, girls that had mastectomies at the age of 13 or 14. Like, that to me is just horrible. And now they're 19 and, you know, they've got no breasts, you know, just mutilated. And I don't, you know, I just don't know. And I think we also have lived with a lot of violence in our world, which is why the young people are heading to violence as well. As I said, there was a stabbing 15 minutes, another shopping centre stabbing 15 minutes away from me today. And it's like, what on earth is going on? And I don't know whether it's got to do with all the lockdowns and all the COVID problems, but I've noticed that since we've come out of COVID, that everyone just seems to be very impatient. People are just a lot more angry, and I don't even know whether that's got anything to do with it. I don't know. Anyway, thank you for watching. If you got this far, thank you. If you're still with me after this rant, thank you. Look, if you could do me a favor, hit like and subscribe, and I'll be back soon. I'll see you next time. Bye.